Sidebar or not, you don't have one of your assistant public defenders say something about my children?
Emotions can run high in trials, and sometimes the camera's there to catch it all on tape. We go over some of the moments when judges just absolutely lost it and when there were intense and unforgettable outbursts in court. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. It's not surprising that trials can get dramatic. I mean, you're dealing with tough subject matter, high stakes, emotions, different personalities. And we have seen our fair share of some of these intense moments here on Law&Crime. So what we figured we would do is do a recap of some of these unforgettable incidents. And we're going to start with 5 times when judges just lost it. And we'll start with a recent case of ours, Darrell Brooks Jr. Now, this was the man who was on trial for driving his car into a Christmas parade out in Waukesha, Wisconsin, back in November of 2021, killing 6 people and injuring dozens of others. And what made this trial very unique is that Brooks decided to fire his defense counsel and represent himself. And not only that, Brooks identifies as a sovereign citizen. This is someone who doesn't believe that the government has authority over him. So what we ended up seeing was just nonsensical legal theories and arguments from Brooks, but also incredibly tense moments between him and Judge Jennifer Darrow. And I will tell you right now, I have never, ever seen what I saw in that courtroom. Brooks was so disruptive of the proceedings. He would get into fights with the judge, and he would bring up things in front of the jury that he wasn't supposed to. And on one particular occasion, this is the one I'm going to bring up, Brooks took issue with how he was provided paperwork, and the judge wasn't having any of it.
It should be properly addressed before the jury even comes out. That's why I tried to properly address it before we even went on the record.
Mr. Brooks, stop.
I'm not going to, this is...
You are not being respectful to this proceeding or to this jury. No, it's not. With all due respect, stating that doesn't make it respectful.
I was given this paperwork by you.
Mr. Brooks,
Monica Paz.
Stop talking till the jury is out.
Okay,
thank you.
So why couldn't we address this before they came out?
I'm not going to address it.
That was the time to address it, though. We're supposed to do all the addressings before the jury comes out, before we start the matter.
Please be
seated. I was trying to simply address paperwork that was given to me by you, Your Honor. That states
Mr. Brooks,
it states that
you have interrupted me repeatedly. You are on the verge of being removed to that courtroom. I don't want to do that. I want you to stay here. But you keep interrupting me and bringing up irrelevant matters. I told you yesterday, as a courtesy, that was provided to you so that you would frankly not complain that you didn't get it as quickly as possible. Okay, I am not the custodian of the records. If you have an issue with what was provided to you, how it was provided to you, then take it up with the clerk of court. But from now on, I am not going to be the messenger and give you documents that you request to the custodian of the records or from the custodian of the records. They will simply have to be delivered to you at the jail. But that is in response to your discussion or whatever we want to call it this morning. I'm not taking it up. All right, it is irrelevant.
It needed to be noted for the record.
It doesn't need to be noted, sir. Previously, I'll make the appropriate record. Stop interrupting me. The jury's coming out. We're continuing with this trial despite your repeated efforts to disrupt. Yesterday, sit down. Yesterday alone, sir, 17 interruptions, not including the opportunity that I gave you where you spent 15 minutes, okay, discussing what were primarily either irrelevant or baseless accusations and requests not based in law or fact. I was abundantly patient with you yesterday.
And you still haven't verified by proof any of what I said.
And none of that is required, sir.
Because it is. You can't verify.
Your belief that that's the law doesn't make it so, Mr. Brooks.
And that is just a sampling of what we saw between them. You know, Brooks would be kicked out of the court multiple times, and this all ended with Brooks' convictions across the board. The jury found him guilty of 76 criminal charges, including 6 counts of first-degree intentional homicide, and he faces life in prison. Moving on, let's go to the Kyle Rittenhouse case. Very high-profile trial of the 18-year-old, also out of Wisconsin, who was charged with first-degree intentional homicide, reckless homicide, attempted homicide, and reckless endangerment for opening fire during a night of civil unrest out in Kenosha. And this trial, this case, raised important questions of self-defense after he shot and killed 2 men and injured a third. Now, in this interaction, Judge Bruce Schroeder took issue with how prosecutor Mark Binger was questioning the defendant, who decided to take the stand, on issues that the judge ruled were inadmissible at trial. Now, Binger says, well, look, Rittenhouse opened the door to this line of questioning with his responses. Let's just say Judge Bruce Schroeder, didn't quite agree.
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
My understanding of
You should have come and asked. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
The defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. That's absolutely untrue. No. Your arguments of record...
This was a moment, for sure. And, this case would actually end in Kyle Rittenhouse's acquittal. This turned out to be a case where a defendant taking the stand seemed to pay off. Now, sticking with defendants taking the stand, we covered the retrial of Henry Segura. Now, Henry Segura was charged with the horrific murders of his girlfriend, Brandy Peters, and her 3 children, including his own 3-year-old son. The prosecution said that the motives here was a dispute over back child support. Really, really terrible situation. But it was an interesting case because the defense had suggested that the murders were actually a hit carried out by a drug syndicate. And what we saw was a retrial. It was a retrial because the first trial ended in a hung jury. And during this retrial, at one point, Henry Segura decided to take the stand. And when he was questioned under cross-examination by the state, he and the judge got into a bit of an exchange.
Well, did you tell her the truth? Did you tell her I was over there just because to see my son? But I lied to you about the sex? You didn't tell him that?
No, I didn't tell her that. Okay. I didn't have a chance to.
Why not?
Because the way our conversation went, the phone call ended abruptly. And I didn't call her back. Okay. And every time she called me, I would refuse to call.
And so your answer is no, that you did not tell police that?
Yes, I told the lady Johnson, Investigator Johnson.
You told
over
her
the phone that I was cheating on my wife. I didn't want y'all to find out. Mm-hmm. And she, and she, like I say, she went back and forth, and we was arguing about, she know I killed my son. We're gonna arrest you for killing your son, and I hung up on her.
So your testimony is that you told police in this case over the phone.
Investigator Johnson.
Wait a minute, don't interrupt her question, Mr. Segura. Let her finish her question.
She's asking the same question over and over.
Be quiet.
No, she's...
Be quiet. Now, she asks you a question.
Who you pointing at?
You wait till she finishes
I'm a grown man.
And then answer it, okay? Yeah. And she won't interrupt your answer either, because the court reporter can't take down 2 people at once. Is that clear? Sir?
Yeah, that's very clear.
Tense. Very, very tense. And for Henry Segura, he was ultimately convicted and sentenced to life in prison. I would tell you, there's just something jarring about hearing a judge yell, right? Because we don't really see it that often. But sometimes, look, judges are human beings and they can only take so much. And we saw this play out in the Alex Jones case. So as you might recall, the InfoWars host had been sued by multiple people, primarily the family members of those who lost loved ones in the Sandy Hook Elementary School shooting, after Jones repeatedly and publicly called the shooting staged and fake and filled with crisis actors. And during Jones's Connecticut trial, he was represented by well-known lawyer Norm Pattis. And Pattis and Judge Barbara Bellis, well, there were some rocky moments.
What that judge is, it's argumentative in tone. He's not an expert. And so what one does isn't what we're here to show. We're here to show what he did.
Right, but that's a different... No, Attorney Pattis. How many times do I have to say when I'm speaking, you stop? You have been a member of the bar for a long, long time.
and you know the rules.
And even during a sidebar, when the mics were turned on, listen to this back and forth.
Attorney Pattis, I'm not going to have the comments anymore. I'm not going to have it. I'm not going to have it.
Do you expect me to lay silently when they're directed at me, but inappropriately? Do you expect me to roll over for my client? It's not going to happen.
As I said before, strong personalities, drama, it happens. By the way, in that particular case, the jury awarded the plaintiffs almost $1 billion in damages. Really just a remarkable, remarkable case. And I encourage everyone to go back to listen to our sidebar episodes on it. But okay, we can't talk about judges losing it without addressing something that recently happened that took a whole other level. During the sentencing hearing for the confessed Parkland school shooter, the shooter pled guilty to 17 counts of murder and 17 counts of attempted murder for opening fire at Marjorie Stoneman Douglas High School back in 2018. And at this sentencing hearing, victims' family members were able to provide statements to the court. This is very typical. We see this a lot of times. This trial, this case was very different. This was just an absolute massacre. And you can imagine these parents and loved ones have very strong feelings. And yes, they certainly directed their comments towards the defendant, but they also directed their comments towards the defense team. And they attacked them for their trial strategy and their behavior in court. And the shooter's defense attorneys took issue with this. They believed that the court should step in and stop it because traditionally these statements really aren't focused on the defense team. They're focused on the defendant. And in fact, the attorney suggested that these comments were dangerous because they were directed towards their children. And during an argument with Judge Elizabeth Schur, the judge started seeing red.
There were 18 witnesses, 16 or 18 witnesses that testified today. There was nothing that was said until Ms. McNeil made her point made, and, we're moving on.
But is the court going to do anything about maybe stopping it from happening again?
When these people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking, Ms. McNeil, be quiet. When these people have sat in this courtroom and watched this behavior from that table and they want to say that they're not happy about it, what is the problem?
Judge, I have no problem because I have thick skin. But once you bring in my children, I think that's highly improper. I
didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
For them to comment on my children is highly improper, and for this court to allow that kind of testimony is also improper.
I don't remember any comments about any children. And if there was, it obviously didn't, it came and went without me noticing it.
Judge, I can assure you that if they were talking about your children, you would definitely notice it.
You need to sit down right now. You're out of line. In fact, you're excused. You need to go sit in the back with your chief public defender.
He's the public defender, Judge.
Mr. Weeks, please ask the lawyer from your office to go sit down and not say anything else. To try to threaten my children and bring up my children is inappropriate. Go to the back of the room now. That just violated about every rule of professional responsibility that I have never. If you're going to get up here and you're going to...
Judge, I asked you to go sidebar on this matter.
You, sidebar or not, you don't have one of your assistant public defenders say something about my children?
Judge, that same venom that the court is expressing is the same venom that defense counsel had to sit through this entire morning when their children
She brought up her children multiple times during the trial. Nobody knows if I'm barren or not. They don't know about my children.
Judge.
Sit down.
And look, there is a difficult question here. Under the law, should parents be allowed that much free rein to go after the defense counsel? Did the attorney act improperly with his statements to the judge? Did the judge fail to show judicial temperament? I think what we can say is that none of this is surprising in that this was an incredibly emotional and difficult case that lasted 3 months. And for the families, they were experiencing this for years. All right, everybody, that's all we have for you. Thank you so much for joining us here on Sidebar. Please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.